If you're buying a house, buying any sort of a property, one thing that you need to be concerned about is if your solicitor mentions qualifying the undertaking, his undertaking, or qualifying his certificate of title. And in this video, I'm going to explain to you what the situation is, what it means to certify title, and what are the implications for both your solicitor and for you. Situation is this, that when you're buying a property, your solicitor is going to act for you and it's going to give an undertaking to the bank, the lender, it's assuming there is a lender, to obtain good marketable title to the property. Now, the bank will rely on the solicitor's undertaking in the first instance, and then when the sale is completed, the solicitor will give the lender a certificate of title. This is a certificate of title of good marketable title which the bank will rely on, and the solicitor is basically putting his professional reputation and professional insurance, indemnity and so on the line to certify title. Therefore, if there's an issue with the property that will cause difficulty for the solicitor and may prevent the solicitor from giving a certificate of title, then the solicitor is going to have to be prudent and is going to have to qualify title, qualify the undertaking. But before he can do that, or she can do that, he or she must first write to the bank and ask them in writing for their consent to go ahead and qualify the certificate, qualify the undertaking, and on that basis is the bank happy to proceed. If that's the case, then that's fine, the thing will go ahead, solicitor's happy enough, he's covered, bank is obviously given their consent, and the purchaser, you, are happy enough, you're getting the property that you want. Now, this will arise in a situation where there may be a problem with title, for example, in relation to planning, in relation to an extension that maybe there isn't planning permission for, or there isn't a proper certificate of compliance for. It may be to do with, for example, an attic conversion in a dormer bungalow where you may have an issue to do with either planning or building regulations. It may be to do with, for example, a right of way to the property. In other words, legal access to and from the property is very, very important, and in particular in a rural area, it would be important clearly that there's a grant of right of way, or an implied right of way, or right of way registered with the Property Registration Authority. In any event, all of these issues are serious issues that might cause or will cause the solicitor to contact the bank and say, look, I propose qualifying my undertaking to you. I'm going to be qualifying the certificate of title. Are you happy to proceed? The bank will say yes or no. Now, a lot of times the people who are purchasing the property, the purchasers, they don't really understand or don't accept, and they think that the only decision to be made is for them to decide to purchase a property or not. But in fact, there's another person in the relationship, and that is the solicitor. And the reason is because the solicitor has to certify title, and is putting professional indemnity and professional reputation on the line, and therefore must ensure that he or she can get good marketable title of the property. So any issues, any problems, they have to be or cannot be ignored, and it's not just a question of the purchaser saying, that's grand, sure, my father will sort it out, or I'll be able to sort it out later on, or we'll go ahead and buy it now and then later on we'll try and resolve the issue. That's not the way it works, because, as I say, a solicitor is not going to put his reputation or insurance on the line, and the bank is going to want to know that if they're buying a property, or if they're securing a property or lending money on a property, then ultimately, if they have to pull the plug and repossess the property, they need to be sure that they can actually resell it. It's too late for them then to discover that there's no planning permission for X, Y or Z, or for a garage, or for an attic conversion or something of that nature. I hope you find this useful. It's to do with, as I say, a certificate of title, the solicitor giving an undertaking, the solicitor qualifying that undertaking, and the solicitor then qualifying the certificate of title. Many times the bank will accept it, sometimes the bank won't accept it, but the solicitor needs to find out first, and it's no harm for you as a purchaser to understand how it works. I hope you find this video useful, and you may be interested in subscribing to my YouTube channel. If you are, subscribe down below, just hit that subscribe button, and if you find the video useful, you might give it a thumbs up down below. Thanks a lot.